Yeah, thanks for spending the lunch hour with me here today. A bit of an overview on the MSPB, procedures and processes and various appeals, most generally. And the webinar here is targeted towards federal employees, of course. So that's what we'll be discussing. Not necessarily any fact patterns specifically, but again, just sort of a general overview, a bit of a primer into MSPB. A little bit about me. You see my bio there. I've been with the firm for a number of years now. I practice mostly administrative law in the federal sector. I do a host of other employment matters and state law, state court as well here in Pennsylvania and in Washington, D.C. I've done a lot of these MSPB cases over the years in various sort of jurisdictional prongs, as we'll be discussing. So that is a little snapshot of what I do. We can go to the next slide. So what we learned today, again, a little bit of an overview, a little bit of everything. It's certainly not meant to be comprehensive. One thing you'll learn about board law is there are a lot of exceptions to the rules. So these things are ever changing, especially in the last year since the board has been issued a quorum. You've been seeing a lot of precedential decision, both from the U.S. Court of Appeals for the Federal Circuit, as well as the full board. So, maybe years prior, you weren't quite seeing that level of precedential decision. So these things sort of always are in flux through case law, through regulation that can often be interpreted differently. So, yeah, well, you'll see that, things that may seem straightforward are not. But my goal here is, again, to kind of give an overview of sort of the issues that we look for as practitioners that, attempt to help our clients. And that's something that we will discuss at the end. So, high level stuff. What is the Merit Systems Protection Board, or the MSPB? What matters does the MSPB have jurisdiction to hear? Excellent question. And how to appeal an unfavorable decision from your internal agency, and then the different stages to be aware through a MSPB appeal, and then finally, again, the benefits of hiring someone familiar, an attorney familiar with these procedures in your specific case. That's what we'll be discussing. All right, so Merit Systems Protection Board, or MSPB. So it is an independent quasi-judicial administrative body. Really kind of delves into federal law to address some of the lingering issues with the spoil system in the federal sector. I mean, that's really where the board was founded. Merit Systems Protection principles developed from that concept. 9 of them sort of aspirational in nature. You can easily find them on the board website. Basically all centered around equity. I mean, that's really what those 9 merit system principles really are really there to address. And as a corollary, written in the negative over the years through statutory law, namely 5 U.S.C. 2302, there has been 14 prohibited personnel practices that have been written in the negative, prescribing agencies to do various things. So, that's certainly those 2 things really center the framework on the origins of the MSPB, what really their mission is, and making a fair and equitable as well as efficiently run federal government. So, basically, umbrella-wise, the board has jurisdiction to hear 2 types of appeal. One is original jurisdiction, and the other is appellate jurisdiction. As you can imagine, appellate jurisdiction, you're appealing something most generally, right? So, often an internal agency decision, an OPM decision, so another agency decision, or a decision within that appellate jurisdiction is codified there in that regulation you see in the slide, 5 CFR 1201.1. Also original jurisdiction. We won't talk too much about that. I mean, it's really generated in nature with cases brought by the Office of Special Counsel, really to enforce those 14 prescribed prohibited personnel practices. So there is authority under the law, albeit those cases are somewhat rare, that the Office of Special Counsel will take jurisdiction, normally over cases of some public import, but they can certainly take jurisdiction and lodge appeals on behalf of individual employees before the MSPB. There is slightly different procedural course with those cases that we're not really going to get into, but that's something that certainly can be done by the special counsel. By law, persons removed from SES, right? You see there, and then administrative judges under, specific section there, 5 U.S.C. 7521. I suspect that not a lot of our audience has any claims relevant to those points of law, but they are there. Next. All right, so we're going to spend a little bit of time here on MSPB jurisdiction, and sort of the way these slides are oriented, they just really jump into basically enumerating like every point that's that's memorialized here in this regulation as far as a personnel action that could be appealed to the MSPB. But before we do that, I think it's important to step back and just get a sense on who can appeal, which is normally the first real threshold question when you deal with a jurisdictional issue. And to do that, you really need to look at whether or not the employee, sort of layperson's terminology of employee, is legally defined as an employee. The MSPB will only hear issues lodged by employees as legally defined. So it's important to understand what that definition is. Again, like anything else in sort of this body, it can get weedy into exceptions and agency appointment authorities, et cetera. But really when you're looking at it in sort of a high, sort of a 10,000 foot view, you're looking at a competitive service employee, which basically is defined through, again, statute and then memorialized in reg. The statute there is 5 U.S.C. 7511, very important MSPB statute to determine whether or not the initial question of whether the petitioner is an employee as legally defined, and that's codified through 5 CFR 752.402. The point there being competitive services versus accepted services, sort of umbrella type appointment authorities that you'll most often address in the federal space. So competitive, either it's a non-probationary employee, which seems sort of intuitive, right? It's a non-probation employee, or 1 year continuous service in the same or similar service. So basically 1 year for competitive service. And then with respect to the accepted service, same sort of legal framework if you look at the wording there, but sort of in layman's terms, right? 2 years of continuous service in the same or similar service. And there are circumstances where we see agencies misidentify whether or not the employee is actually a protected employee. There are case law. There is case law out there that that some service can tack on to other federal service that would render an otherwise probationary employee to be a tenured employee under this circumstance. So there are certainly issues with respect to that. In fact, prior to looking at these slides, I checked out some of our own firms webinars in the past, and I know we have done due process webinars that go a little bit more in detail with respect to a lot of these different issues. I highly recommend checking those out. But certainly competitive versus accepted service, important to understand when you're dealing with general sort of appellate actions in these form. And I'm going to talk a little bit about what you see most commonly, and predominantly you do see a lot of adverse actions, which is performance or conduct-based issues. So, when you're dealing with those type of actions, you'll hear that under a title, under a chapter 75, which denotes some sort of discipline. Most generally, it can be performance, or chapter 43, which is a performance-based statute. You're really first looking to see whether or not that's a tenured employee, right? Basically a non-probationary employee. And to do that, most often you're looking at that appointment authority, how that was coded on a standard form, how they were brought onto the agency, how the employee was brought onto the agency, and sort of then it's a date calculation, right? Whether or not the competitive service meets that time and grade, and whether time and service, and same with the accepted service. So that's the threshold portion of that analysis. I think that it definitely warrants consideration before you jump into what's next here on the slides, which is agency actions, right? So, again, this is also memorialized in regulation and through the U.S. Code, but personnel action, we're looking at, predominantly, and there's the 3 slides on this. So I'm gonna highlight some of the ones that I think that we see the most. Well, I know that we see the most. So, number 1 there, reduction in grade for based on performance. This would be a Chapter 43 action. What's quote unquote an employee can appeal those types of actions, basically demotion. Number 2 there, the vast majority, you'll see this. Basically some sort of discipline, right? You can think of it as 15 days or more severe. There are board rights. Anything less than that, there is no board rights. There may be internal grievance procedures, etc., or there's other causes of action that may be available to that employee, whether it's EEO or some sort of administrative issue, grievance issue, or union grievance, but as far as a board right, there is none. With those lesser forms of discipline. Now, that being said, there's still due process requirements and those types of things. So again, I'd urge you to go back and take a look at the other video that I referenced there. Removal or suspension of a senior executive service, a little bit smaller subset of cases, but certainly there's jurisdiction of the board for that. You have a RIF provision there that's next. The other point here, determinations affecting rights or interests of an individual under the civil service retirement system or FERS. That's important. Basically, OPM is delineated as being the final adjudicator in those types of cases, and any final decision from OPM can be appealed to the board, and whether that's a determination on first disability retirement, or perhaps just general calculation as far as the substance of the employee's ability to collect on retirement, or what those calculations are, whether there may be an issue of a high 3 calculation or the employee's time in service, etc. So those things are reviewable by the MSPB. Suitability determination, sort of these first steps of the suitability determination, whether it's a competence issue or suitability determination on a given appointment, are appealable to the board. Termination of employment or probation in the first year of veterans readjusted appointment. You'll see that here, and it's also, I noted, not on these slides. I mean, it's given rise to a fairly significant body of law under the federal service. USERA, the Uniform Service Employment and Reemployment Rights Act. Jurisdiction lies before the MSPB to hear those types of cases, and those types of cases can be reemployment cases, or they can also be discrimination cases. Similar subset of cases, VIOA cases, Veterans Employment Opportunities Act. Anything dealing with a veterans preference issue are appealable to the MSPB. So those are things to keep in mind. So we can move on to the next slide. So yeah, I mean, you can take a look at some of these. They're fairly narrow. I don't know if we need to get into all of them. Some of them actually get extremely narrow. So we can spend a moment kind of highlighting these slides. But again, civil service retirement system, those decisions are appealable. We have suitability reference there. Termination of appointment during managerial supervisory probationary period. So that's something to take a look at when it involves a certain category of classification. Failure to reinstore following an absence of leave, that sometimes comes up. You sometimes see that fact pattern. We can move on. So again, extremely narrow, some of these, right? Haven't to date seen the Taiwan Relations Act issue come up, but if you're a potential client out there and have that, I'd like to chat with you. So you see those at 5 CFR 1201.3. All right, so kind of outline what law dictates as far as appealable actions there. And I mean, bottom line is by far and away, the most common are adverse actions by the agency. In fact, prior to checking out these slides, I went on to the MSPB's annual report. When they do annual reports, great summary of information from the MSPB over year's end. Most current one is 2022. Again, a lot coming out of the board that year because of the quorum that happened in, I believe it was March earlier in 2022. So you really see a lot of law coming out at that time, but they do a little bit of a interesting sort of analysis as far as what types of appeals were decided in regional offices and field offices. So around 40% were adverse actions by the agency. So you're looking at, in that case, Chapter 75 really issues are most their most common area of statutory law that those actions are brought under. There are exceptions, again, exceptions to a lot of these things. That, if you're a VA employee, there might be some different considerations or points of law that would be controlling. But when you're talking about sort of the general scope of the federal government, Chapter 75 actions, adverse actions by the agency, nearly 40% of the board's docket. Individual rights of action, right? You're talking about whistleblowers in that case, right? So whistleblowers that bring a independent cause of action or an individual right of action under 5 U.S.C. 2302 B8 or B9, basically that says, if you're a whistleblower is legally defined and you exhaust your administrative remedies through the Office of Special Counsel, you can file a board appeal at the MSPB. So there's jurisdiction there to hear that case. As a corollary, if it's a B9 case, it would be, some sort of complaint that was reprised on, lodging on some sort of whistleblower grounds. Anyway, about 10% of the docket there on the IRA cases. So that's pretty interesting, somewhat high. And then you have the USERRA and VIOA cases, 2 and 3% respectively. So a little less than I actually would have thought there, but there's about 3% of military issues that the board's hearing right now currently in its docket. Probationary terminations, again, those employees that do not satisfy the statutory definition of employee, about 10% of the cases are being heard on those grounds. Incidentally, it's not just simply thumbs up or thumbs down. There are, as far as whether there's an employee, there are limited rights, whether, it could be some sort of political affiliation issue or familial status or something kind of narrow in that regard. You can potentially get jurisdiction at the MSPB on, a non-probationary or a probationary employee status. But, presumably there are some clients that don't, that obviously don't understand that and just file without knowledge that, they're probationaries, and ultimately those cases are dismissed. Now you have performance cases under a Chapter 43 standard, about 3% of the docket. Now that was surprising to me. I thought there would be more. There are several different things there to consider. I mean, when you're looking at those, it's a little bit outside of the purview of what we're here to discuss. But basically, when you're looking at those things, you need to look at sort of, the Chapter 43 is basically looking at a position description, whether the agency has the burden of proving a performance deficiency, right? Unlike 75, where there is no such standard, right? There is an efficiency of the service standard under Chapter 75 standard, right? There isn't on the 43 standard. There's a whole different burden of proof, which is significant. Preponderant evidence on the Chapter 75, substantial evidence, which is actually a very, very modest threshold of evidence there on Chapter 43. Generally, Chapter 43 action takes more agency resources to go through a process of a PIP. And you're doing those things, performance improvement plan, and documenting the employees. But, sort of a corollary, those cases can be more difficult for the employee to prevail. Sort of depends on how those things are structured. But, and again, getting outside of really what we're looking to do in this webinar. And the MSPB has a nice sort of chart on that outlines those actions. But getting back to what we're here kind of discussing is adverse actions by the agency is sort of the overwhelming at 40% of what you'll see, in these cases, and likely, the most of our potential clients come in with those types of actions. Now, getting back to the stats, the board through regional office and field office settled nearly 55% of these cases, so quite a bit do settle. Interestingly, mitigation, which is only relevant in a Chapter 75 case, 1% of those cases, so not a lot of mitigation in last year's numbers. And 35% basically of those cases affirmed the agency's underlying decision. So a little bit about the board's numbers from last year. We can move on from this slide. All right, so now we're kind of getting beyond the initial threshold jurisdictional questions and looking into how this goes about filing. Yeah, these slides are sort of, I guess by default, looking at the adverse action, the 40% of these cases, right? So this is sort of kind of how that's laid out. Also with the Chapter 43, it wouldn't change your timeliness issue with respect to what we're talking about here. So those big subset of cases are namely addressed in these slides. So the process of filing the appeal, 30 days from the effective date of the decision letter at adverse action. You know, occasionally you do see facts where an agency will issue the decision on a certain date, and then a few days from now it will be effective. You know, technically under the law, the effective date is controlling, the latter date is controlling. You know, as far as our practice, my practice generally is to file on the date of issuance or before to sort of avoid an unnecessary timeliness issue. But that's what you do. MSPB, you know, here we're going to look at, I guess, the old standard form, which basically tracks what's online. For years now, the MSPB has adopted the appeal system. All the pleadings are on the MSPB website through their repository. Once you're designated as an e-filer, you can access all that information, you know, if you are the employee or the attorney. So it's a pretty streamlined system. You know, as of this recording, they are doing maintenance to that system for, I believe it's some month or so. So it's changing a bit on their filing procedures, but all in all, a pretty seamless thing there that they have with respect to service of documents. You go on there, indicate your intention to file appeal. Again, sort of click through that. Go, you can move on with the next slide here. And so, I mean, it's straightforward. I mean, some of this is, you know, really just entering form information, data compilation there. I mean, one thing I'll flag on 11 hearing, generally want to click that box. You know, certainly if you're unsure, you can withdraw your request for hearing at any time. However, you may not be able to request a hearing if that box is unchecked. So that's important. I believe it's 12 there on the screen. You're identifying the action. That's sort of shorthand from what we went over on those slides. Then what do we got? We got 16. 16 is basically, although that's fairly small, I believe that's you're at that point you're attaching, right, the agency's proposal, the decision, any SF50. It's marking the adverse action, right? So you're providing the board that initial sort of information so the board can, you know, determine whether or not it is a personnel action for which it can hear, right? Sort of fields 1 through, just say, 10 or so is getting into whether or not you're an employee, right, of the board can confer jurisdiction upon. So but anyway, getting back to 16, right there, you're basically identifying the issues that the board will hear based on the nature of your claim, right? So if it is a Chapter 45 claim, you're identifying the charging letter, you're identifying the charges, the specifications, you know, how the agency cannot meet its burden of proof in that case, majority evidence. So you are addressing sort of line by line that charging document. If there is any argument to the efficiency of service, it would be made at the time. If it is a case in which the Douglas or mitigation factors are present, you would be listing those at that time. Certainly, if there's any affirmative defenses, which you know, it's basically one or more of those prohibited personnel practices that were outlined in, you know, 14 of them, which are, you know, memorialized through statute. If there's any relevant prohibited personnel practices, you're identifying those. So if there's any due process issues, say you weren't given, you know, proper evidentiary file or notice procedures or something like that, or there may have been a communication violation on part of the agency. I mean, these are all issues that the lawyer on your behalf would be looking for. Those would be noticed in this document to the extent they're known at that time. So we can move forward. So these are specific, and based on the entry that you're providing to the MSPB contemporaneously with that submission, it's going to bring you to various parts of this form. So some may not be relevant or applicable. This appears to be more along the lines of a retirement benefits question form. So you may be filling this out, you may be filling something out that's independent to a whistleblower claim, right? So the point here is that the form is complete. It really is your appeal, right? So once this thing is combined, it does serve to be your appeal. So we can move forward from this particular slide. Finally, you're listing your representative on this form. Signature on the form, and then again, it's uploaded. It will be date stamped on the board server. Important to retain a copy of that date stamped document for the purpose of service. Once it is filed with the board, then it is deemed served upon the agency. So yeah, that's the controlling date. We can move forward. All right, so you filed an appeal. Now you're looking to process that appeal. So MSPB is a fairly quick jurisdiction as far as hearing cases. Their judges are evaluated just like employees are evaluated, right? So they have 120 days to generally hear these cases. So they're looking to move these cases along. Not to say that you can't get extensions, or there's ways to sort of massage those numbers, whether it's through dismissing the case with prejudice, or again extending deadlines, or staying case deadlines, or suspending them, or what have you. But generally, once you file an appeal, sort of to really get your day in front of a judge, which is a right that is by law, and really byproduct of the U.S. Constitution, you have the right to get before that judge. There is no really meaningful dismissals unless there would be a jurisdictional issue. There's no such thing as a summary judgment motion, for example. You're going before your day in court. So it moves. I mean, that's one of the things with the MSPB that can be good, can be bad, depending on the facts of the case, but they're generally fairly prompt at processing case. So that being said, the MSPB does notify you of an appeal within generally 15 days of filing. I've seen it sometimes within 2 or 3 days. You get an ACK order. Yeah, that's pretty common. This ACK order is just that. It acknowledges your appeal. Is basically some of the housekeeping items early on about how the judge likes to process a case. As far as anything from formatting pleadings to communicating with the judge, certainly written to someone that doesn't, practice a lot of these cases, right? To an employee that's coming on this as a first, through the first experience with an MSPB case. So it does explain how the judge would like sort of the quorum of the proceeding. Now, it does also lay out a discovery timetable. Often it does. So he has normally a 30-day period to initiate discovery requests, which discovery, as you may or may not know, is really tools to, well, in this case, it's written discovery, tools to understand more about your case, whether that's through interrogatories, admission requests, or production requests. Really aim for getting relevant information, whether it's good or bad, relevant information about the nature of your case. These are sort of structured in a way, that at least through counsel, that is tailored to hopefully get as much information as possible, certainly relevant information as possible, based on the nature of those requests. So, the lawyer will know what elements of a case you need to prove. So those requests will be written as such. There's different requirements as far as whether or not a party can issue second rounds of discovery. At the board level, you can. There's timelines for that, for example. There's timelines for responses. Generally, a party has 20 days to respond to a discovery request that's initiated by the opposing party. So those are the types of things that are outlined in that acknowledgement in order. briefly there on that last slide, there was a point about a motion to compel. There is opportunity to file such a motion, if necessary. The goal, I believe probably of all parties, including the judge, of course, is to avoid those types of things. But, the idea is the parties work together to try to obtain that relevant information. But sometimes that doesn't work. Sometimes there is an impasse over, what may be relevant or what the agency is willing to provide or what the appellant's willing to provide. So disputes do happen, in which case there is sort of a motion to compel regulatory framework that basically alerts the judge and requests his or her intervention to get, that information. So there is that aspect of a case. Process of filing MSPB appeals continues. So now we're moving forward through written discovery. During the course of this period, you'll often see the parties engaging in settlement negotiations. I mean, as these cases go further and further towards a trial, administrative trial, you're incurring more in attorney's fees that can become costly. You're getting a better sense of the record, right? The agency by this point has issued an agency file that's within 20 days of that acknowledgement in order. So you have a fairly good sense on the record, the scope of information in your case. So it's a good time to try to seek middle ground with the agency if possible. I mean, sometimes these cases are hard, right? I mean, sometimes there's, the agency is dead set on, keeping that employee off of the rolls, and the employee is dead set of getting back on the rolls, right? So those types of cases can be difficult to settle, but it's still certainly worth exploring. During this sort of case processing procedure before the close of discovery, which realistically is the pre-hearing submission, you have opportunity to take depositions. And I mean, in these MSPB cases, depositions can be very important. In my practice, I found that they can really make or break a case, especially if you're dealing with, certain personalities in management, I guess you could say. If you're dealing with sort of, we really want to know the deciding official in certainly a termination case, something like that, or a performance case, right? Because there's only so much information you can garner from a written discovery request. It really is helpful to understand this person's testimony or projected testimony prior to the hearing. So that's going to help color settlement as well. So you have the opportunity for that. So all this is building a record and is accumulating to the pre-hearing submission. So pre-hearing submission, you're including the facts of your case, the witnesses, and the evidence that you want to introduce. Basically a roadmap, if you will, of what your case will be at the hearing, whether or not there will be affirmative defenses, whether or not you're raising due process issues, whether or not there's going to be some sort of damage component of witnesses or an expert witness, or, whether or not, there needs to be some sort of motion that needs to be addressed by the judge. All these things can be presented and should be presented in the pre-hearing submission. So these, it's a notice pleading. You notice these through pleading format, and then you're moving forward to the pre-hearing conference, and then you're going to be discussing those things at a conference prior to the hearing itself. So, through the pre-hearing conference, you're really discussing how the judge wants to present the logistics of the hearing and how the judge expects the hearing to proceed. Certainly in recent years, a lot of these have been virtual. You see that pretty commonly. So that's something that's addressed at the hearing about witness ordering, the time of the expected time of each witness. Maybe there'll be some issues for questioning about, the scope of direct examination, cross-examination, redirect, something like that. And then, all the idea is basically to have the hearing go smoothly. So that's done at the pre-hearing conference. So then you're at the hearing. So, this is basically what all that work is culminated to do for that hearing, for your day in court. And you're going to be, presenting your case. Agency will be presenting its case. Agency has the burden in a lot of these cases, could present the case first. Depends on the nature of the claims. If you have, for example, whistleblower case, you would have the burden of proof. But in any event, same sort of general roadmap applies. You're hearing witness testimony. You're looking at the agency file because, of course, that includes the record. You're looking at any other information that was produced and accepted through any kind of discovery, right? You're asking witnesses various questions, and sort of the agency is doing the same. So that takes its own coloring through the hearing process, and then yeah, I mean, all these things, I do see these notes down here. I mean, you do see this during the hearing or even the pre-hearing. They're going to explain the procedures, exchange of any discovery that could be admitted for the purpose of the hearing, identify and narrow the issues. Certainly judges want to narrow those issues. It's great if the parties can stipulate to some of those things prior to hearing to sort of streamline again the possibility, the days of hearing. Discuss the possibility of settlement. Never too late to settle a case. I mean, even during the hearing, you can discuss settlement, rule on the witnesses, and rule on the exhibits. So, yep, all these things happen at the hearing or even before the hearing, so we can move forward. So the judge will issue an initial decision at some point after the hearing. On rare occasion, that can be at the hearing itself, but more generally, it's through written decision some days after the hearing. Could be weeks, could even be longer. But the judge will issue a decision, and there are appellate rights associated with that decision. Once the initial decision, prior to that decision becoming final, you can petition for review. That goes to a 3-person panel at the MSPB or the full board, as you often hear. So that could be appealed to that body for a determination. Likewise, you could also file an appeal to the U.S. Court of Appeals for the Federal Circuit. So that's an appellate option as well. Okay. So we're on to benefits of having an attorney. I mean, the benefits are numerous. Just to get a case off the ground, there's a lot of thought that needs to go into the case, how to best structure a case, how to best present your evidence. The bottom line, if it's not in the record and you're trying to appeal to one of those 4 that were referenced in the previous slide, you're not going to be able to do so because you're not going to have an adequate record. So really, I mean, the lawyer is crafting a record on your behalf, is objecting to whatever rulings that the MSPB judge may or may not make that presumably are not in your favor, right? So, record control is a huge aspect of hiring a lawyer, in my opinion. Negotiating, also very important. I mean, you can be the most sympathetic client, but if, you're not presenting, again, the facts in a salient way to garner the attention of the agency or its representative, you're not going to be necessarily getting the maximum value of your case. So negotiating with the agency to settle is in your best interest. And it also removes you, right, to some extent from those negotiations, because no matter what kind of personnel action, as described in earlier slides, you experience, it's going to be a pretty raw emotional situation for you to get on the phone and discuss really from the agency's mouthpiece why they took the action they did, right? So that's going to be a hard call. It's not going to be necessarily an easy one to make. And you may be colored by emotion rather than facts and law of your case. So important to have a advocate to do that on your behalf. Ensuring timeliness. Also, I can't tell you how many cases that sort of dead on arrival. Unfortunately, they get to this law firm a bit too late, and there's no case. So, these deadlines oftentimes are statutory. They're inflexible, and it can lead to really unjust results. But it's the law. Establishing MSP jurisdiction, right? You're not going to be able to tell your judge or even get to the merits of your case if you can't get in the door to do so. So, establishing jurisdiction is really a huge battle in a lot of these cases. I mean, some they're not. Some jurisdiction is fairly straightforward, but if there is sort of an outlier issue, definitely want to consult legal counsel. And then you're right, mitigating factors. That's one aspect of these Chapter 75 cases that are something that need to be addressed. I mean, certainly are addressed. I mean, oftentimes you have stellar employees that have long, lengthy careers, circumstances in which the agency is not employing progressive discipline, circumstances in which comparator employees were treated, more favorably under similar circumstances. You have employees with extremely high rehabilitation potential, potentially as supported by individuals in the community or what have you. So there's a lot of evidence out there that can be presented in these mitigation circumstances. So that's something to certainly hire a lawyer for. I don't know if there's another one. Is there another slide? Okay. So
We can open it up to questions now. If anybody has any questions that they came up with during the presentation, please send them via chat and I will send them over to Ryan.
there were two I think I saw that came in prior to the webinar. Let's see. A lot of questions often in these things come up around EEO issues, and they really are fact specific. It is considered mixed case. A lot of these issues are a mixed case, and there are jurisdictional wrinkles in these cases. And I mean, the long story short is the EEO has jurisdiction to hear EEO cases, discrimination cases. So if there is a animus-based question, race, sex, national origin, religious affiliation, disability status, age, prior EEO activity, that is in the purview of the EEO. And the MSPB hears the appeal actions that we discussed earlier, appealable actions that we discussed earlier in the presentation. Now, those things often, or not often, they can overlap. And when they overlap, sometimes you're into a mixed case situation. For example, if your issue is a firing or removal, we'll just say a removal, when you are a tenured employee and you have due process rights, the MSPB is the jurisdiction to hear that issue. Okay. But there could be an affirmative defense of discrimination, right? But the MSPB is ultimately hearing that particular issue with the affirmative defense of discrimination. However, you could be an employee experiencing a hostile work environment at work, and there can be sort of a long history of discrimination at work, which is accepted into an EEO complaint, which ultimately goes before a commission. And the EEO would have jurisdiction to hear that. But say the last claim potentially in that timeline is the firing, the removal, right? That case then has jurisdiction before the MSPB. So then you get into a circumstance where you do have a mixed case. So the non-mixed issues are going before the commission. The mixed issue is going before the MSPB. So there is some overlap there. I mean, and then when you're talking about appeals process from the MSPB decision, then they can go to, various federal courts. So, yes, they do overlap to some extent. I find maybe they don't overlap to the proportion of questions we get on this, right? I mean, it's a smaller subset of cases, but oftentimes you do see discrimination leading to a removal, and sort of the rule of thumb is the MSPB would hear that case. Now, sort of election to file, you could file that removal with your EEO office. At that point, you would go through an EEO counseling period. You would get your notice of right to file your complaint. You would file that complaint, and at the end of a truncated investigation, a 120-day investigation, you would then file that case before the MSPB. The point being, the MSPB would have jurisdiction over that issue, right, on the removal. Now, say the issue was, say the last issue was that, the supervisor alleged that the employee was lacking candor, and that was without justification, and that lack of candor ultimately gave rise to the removal action. Well, that simple allegation, is not a mixed issue. That is still an EEO issue, and that would go before the EEOC. So it's kind of conceptually, without jumping into the myriad of different circumstances where there may be exceptions to what I just said. That's basically the conceptual way to think about it. I mean, if you're dealing with something that's defined as an appealable action, the MSPB has jurisdiction. Other issues that could potentially involve discrimination are going before the commission. I had one. After filing an EEOC complaint, can you still file with the MSPB for further damages? You know, kind of corollary from what I just discussed. I mean, these administrative fora have jurisdiction to hear different things, so there wouldn't be any circumstance where you would be trying the same case, the same issue on its merits between both MSPB and EEOC. You know, there's no quote unquote double dipping, and these you can't get an unfavorable decision one and then go back to the other. You can appeal those decisions, but if you're looking for trial level decisions, you can't just ping pong back and forth and look for the best outcome, or take both, both decisions, because the jurisdiction again is delineated based on what is an appealable action. Let's see if we had any come in. All right, so I have one. The agency is dragging on discovery and depositions. Can anything be done to move it along? It's a good question. I mean, it should really be dragging, to begin with. I mean, if you're having someone that's overseeing your case, I mean, certainly it's not my position to let these things drag. It's a little different in MSB context because it's a burden of proof. It's hugely different than an EEOC case because it's your burden of proof. I mean, evidence doesn't get better over time, right? So in an EEO case, it's very problematic, but in an MSBB setting, it's problematic as well. I mean, I want to get my evidence so I can ascertain, the best course of action for my clients. And in my opinion, that happens earlier than later in the discovery process because again, these cases get expensive. So I want to try to understand, the strengths and weaknesses of the case earlier than later. So it is a fair point to kind of ask about how to push that along. I mean, the way to do that is you can only really push back so much as defined by law. You, as the employee, have all the responsive information to the agency's request, right? I mean, it's just simple me picking up the phone call, having an hour discussion with you, and then being able to fill out discovery or at least have a roadmap to fill out discovery on your behalf. Now, with respect to the agency, it's a little different. They are the custodian of all responsive information by definition. So, there are sometimes delays that are reasonable. They need a protective order in a certain circumstance, and that's something that they're gonna demand and likely gonna get through some sort of adjudication about that issue. So, maybe that's a circumstance where you're not going to push back all that much on the timeliness issue, or in circumstance try to limit that through a proposed order, through a motion saying the parties agree to a stay, but the stay is only for 3 weeks for the sole purpose of taking a deposition over this one fact witness, for example, or whatever the case may be. So there are a lot of ways to sort of curtail that, but the general rule is you file those discovery requests, and then within 20 days they need to respond. Now, if they haven't responded, that's when you start getting into that motion to compel. But you can't just go to the judge right off the bat saying, hey, listen, judge, this agency's not complying with your order. Instead, you need to, have that conversation with the counsel, which is again somewhat uncomfortable if you were just, in the hypothetical fired from this agency. So it's another benefit of having the lawyer to do that. But, if a lawyer's crafting discovery that's appropriate, that lawyer can articulate on your behalf why the agency isn't complying with that, or determining why there is a delay. Maybe there is a switch in counsel. Maybe there is some sort of personal circumstance, and more often than not, a judge is going to be understanding of that. But, at some point, the judge won't be understanding of that, right? I mean, if this is the third delay or the third lawyer switch, and you're talking about this case moving on, I mean, again, they're being evaluated on how they're wrapping up their case docket, and this, say in the hypothetical, the agency keeps switching out lawyers or keeps really proffering cause that's not good cause about why this thing is delayed, then eventually they're going to deny any of that and going to write a strict order on your behalf. But it's sort of how it's an art how to go about doing that to sort of advance things, but not pick the wrong battles where you're angering the judge or it's just not it's not productive. So there's sort of a lot of facets with that, but at the end of the day, communication with the agency is huge. Your adversary, I mean, it's all about, no gotcha motions or pleadings. I mean, you're realistically trying to work through the agency to determine what is the delay, why is there delay, making that determination why if there's cause at all for that delay. So, good question. Can I call the last judge as a witness? Is a question. I don't know. I don't really understand that one. You wouldn't be ever calling a judge as a witness by definition. There wouldn't be certainly a fact witness, right? Unless somehow a judge would be involved in the fact pattern. In that case, the judge would be recused. So, no, I mean, the judge wouldn't be a witness. You would never be calling a judge as a witness. You know, it's important to really give a lot of thought onto the witness, right? I mean, if, you know, a judge is not going to necessarily, I mean, if it is MSPB, say, removal case, they're going to give a little leeway with the quote unquote character witnesses. But the judge isn't going to line up character witnesses for weeks to testify how great of a person you are, right? So, you know, it's important to sort of, again, when with help of your counsel, to identify the best witnesses, the ordering of witnesses, the expected testimony. You know, that lawyer is going to be communicating with the witnesses, interviewing those witnesses, have a very good understanding of the proffer of those witnesses, and really have a good understanding of what that witness is subjected to in cross-examination. So, you know, there's inevitably going to be credibility issues. There's inevitably going to be issues that the agency raises, and, you know, a good advocate, of course, knows these things. So, or at least can plan for them to some extent. But anyway, you know, certainly hearing is an art form, and behooves you to hire counsel for that process. I'm told, I believe that that is the end of questions. And we're a couple minutes early, but did well. All right, well, again, thank you for your time. I appreciate that. And feel free to contact me if you have any questions about the MSPB process in general. And thank you, Taylor, for organizing this event here this afternoon.
Thank you so much for everybody attending today's presentation. This presentation was recorded and will be sent to all attendees following with the PowerPoint. Thank you to Ryan for presenting, and I hope everyone has a good rest of their day.
Thank you.